I'm sorry that we're sitting slightly late. It's my fault entirely, which makes rather hollow my complaints this morning. But my only plea in mitigation is that I was addressing a group of students. Right, Mr. Knox.
My Lords, before I turn to my arguments, can I just summarise what my three main submissions are? The first is, I say that on any view, the Court of Appeal's order that there be a retrial should be upheld against both appellants because, first, the Court of Appeal found the actus reus, to use that shorthand, proved, and for that reason alone, as a matter of law, or at least as a matter of common sense, there was a prima facie case to answer, even if guilty knowledge was required on any of the relevant offences.
It's slightly difficult to understand how there could have been a decision that there was no prima facie case.
As a matter of law, it will be my submission, once in this type of offence the facts, the actus reus has been proved, then special defences like mistake and accident and so forth are matters which are really for the defence to raise.
Well, they have to be raised at least.
By evidence, and they hadn't been. So I say that's the first reason, but alternatively, I say in any event, in this case, on the evidence, I will deal with it very briefly, I hope. The evidence showed positively a prima facie case of guilty knowledge. So for that alternative reason, the order's correct in any event. Second, I say the Court of Appeal was right to say, bearing in mind the facts and issues of this case, that the offence was one of strict liability, and therefore both appellants were guilty. And thirdly, I say if the Court of Appeal's test was too strict, its order is still correct because on a proper construction, the appellants were guilty unless they could show or raise a doubt as to whether they acted under an honest and reasonable mistake of fact, and there was no evidence of that. My Lords, I propose first to deal with the facts, simply because it's important to see the essence of them, both on the main question of liability, but also on vicarious liability. Secondly, I'll then deal with why I say there was a prima facie case against both appellants. Thirdly, I'll deal with the questions of strict liability, section by section. I'll then deal with the point about the penalty, the size of the penalty separately. And then finally, I'll deal briefly with the honest and reasonable mistake point, if I'm wrong on the main point. My Lord, just the facts. Can I ask you just to go to bundle 1? Because it's important to see the declarations and what the words were of the declarations. And 347, you have what is called the C75 declaration. These are statutory forms passed pursuant to the customs regulations. I'll explain a little bit later quite the significance. But here I just want to show you what the form says. And the first thing, this is what 347. The first thing you'll notice is the name and address of the buyer near the top left-hand corner of the page, Canserve. And then name and address of declarant is Darren Nurse, same address. And then you'll see the number and date of invoice, little box 4, and that's the invoice which in turn, in fact, I'll come to it later, refers to the office desks and so forth. And you'll see to the left of that important note by signing and lodging the declaration and so forth. So it's an absolute declaration that he accepts responsibility for the accuracy and completeness of the particulars given and so forth. My Lords, you'll note it's not a declaration to the best of his knowledge and belief. Dropping down the page to little box 8, about 2/3 of the way down, 8A, are there any restrictions as to the disposition or use of the goods by the buyer other than restrictions which, and so forth. And then you go over the page, you'll see the price at the top of the page, and again a reference to the invoice. And then at the foot of the page, box 16, two-thirds of the way down the page, you'll see a reference to the cost of delivery, which is in fact the same as that in the bill of lading I'll come to later. And then at the foot of the page, first on the right, you'll see the declaration, and it's important to note the words. I, the undersigned, declare that all particulars given in this document are true and complete, without the addition of words, to the best of my knowledge. And then this goes to the vicarious liability point, or attribution point. Note to box 21, declarations may be made by, and you'll see who the declaration may be made by.
And that's his position, is it? Building manager.
Yes, he's signed it as building manager, but then you have to read that in the context of A, B, C, and D, to the left of it.
Thank you.
Is he an officer of the company?
Well, my lords, I don't know if there was any evidence that he was an officer of the company.
Looking for that, are we?
No. But you can guess what my position is going to be on that. I say one can draw the inference for the purposes of a prima facie case that he must have been. Otherwise, how could he have had the degree of involvement that he did?
Well, declarations may be made.
Yes.
Any employee duly authorised in writing.
Yes. So one way or another, I say, the inference to draw from this document is he had authority, even if he wasn't a member of the board or a director. That's what I submit matters. Authority from Canserve. My lords, that document is signed on the 23rd of June. You'll see that at the foot of 348.
I'm sorry, how is that binding on Canserve? I mean, it's
Well,
his representation.
If they have authorised him to sign this document on its behalf, then it will be liable too.
Well, yes, obviously, but
Yes.
there's no evidence that they have.
No, my lord, except, of course, his involvement.
The fact that he signed it.
Yes.
And
That
that
he signed it, but
he's
Yes.
required to be authorised to sign it.
My lord, I would accept that if, let's say, although this wasn't raised as an issue at trial, if, let's say, in giving evidence, Canserve said, well, I don't know what Mr. Nurse thought he was doing, then that might, depending on strict liability issues, give rise to a defence.
I see, so...
Yeah.
No, I mean, I understand the way you put it. I just wanted to be clear. There's nothing actually in terms to tie Canserve other than the obvious inference that he was doing what he said he was doing.
Yes, and his involvement throughout on behalf of Canserve. When Canserve are rung up, say, come along for an inspection, he's the one who comes, and so forth. So, but I accept, my lord, there's no direct evidence he's specifically a director. But I say that doesn't matter for the purpose of a half-time submission.
Right.
My lord, the goods arrive the next day on the 24th of June. And you can see the invoice at page 345.
Sorry, page.
345. And this is the invoice referred to in the document I just showed you. And you'll see here the name of the seller at the top. Consignee is Canserve. And then invoice date, it's identical. The office furniture is halfway down the page. And then more details are given just under that. And you'll see a note in handwriting. I hereby certify that this is the only invoice involved with this transaction. And that's signed by one Larry Howell, and he was Canserve's customs agent on the evidence. My lords, I can give you the reference for that unless you want to see it. But at bundle 1, page 55, lines 40 to 50. It would seem, my lords, that on this same day, the C75 declaration would have been handed in, together with the invoice, but there's no direct evidence of that. It's just an inference one draws. It would seem also that on this same day, the 24th of June, an assessment was made of the customs duty due. And you get that from a later assessment notice. I'll come to it in a minute, but it's dated later. But it says the actual assessment to import duty and tax is on the 24th of June. On the 26th of June, Mr. Nurse makes an application to move the container to Canserve's premises, and you get that at page 349.
While it's still sealed.
While it's still sealed. Oh, yes, yes. And he gives an undertaking that the seal won't be opened. And at 349, you'll see the application to move, signed by Mr. Nurse, to remove the containers, page 349. And the relevant bit of the oral evidence which deals with this is page 24, lines 41 to 50. See here, removal of containers, consignment, Canserve, and so forth. And you can see they want to move it to remove the mentioned containers under customs seal from Point Lises to Canserve Caribbean Limited, Port of Spain, prior to customs examination for consignment. Now, my lords, my lady, there, in exceptional circumstances, according to Regulation 69 of the regulations, customs regulations, this can be done. So it's not a usual thing to happen. But anyway, he makes his application. On the 29th of June, the C82 form is signed, and you see that at page 342. And you'll see at the top of the page, top right-hand corner, it says it's a C Customs Declaration Import-Export Form C82. The consignee, again, is Canserve. The declarant this time is John Williams, you're just beneath that, although rather confusingly he doesn't appear to be the declarant, or at least he doesn't sign it. So we don't quite know who John Williams is either on the evidence. You can see the total amount that is assessed to be paid in box 24, halfway down the page, or a third of the way down the page, on the right. It gives the total calculation of 37,317 in import duty and VAT, plus, just to the left, 525 being other charges. So that's the total that is eventually paid.
On furniture.
On the furniture, yes, on the furniture. Next, you can see, going down to a little bit to the left, just below halfway down, description of goods. Desk, file cabinets, metal, bookshelves, and so forth. And then, my lords, there's other slightly confusing numbering, but my, I don't need to take you to that because there is an explanation, but it's rather complicated. You'll see two-thirds of the way down the page, installation kit packed in one carton. And then fifth point, right at the bottom, paragraph 48, going across the left-hand part of the page. We hereby declare that all particulars on this declaration to be true and that all attached documents refer to the goods as declared. So again, it's absolute. It's not put into the best of knowledge or belief terms. And then warning right at the foot of the page.
The purpose of this declaration is to settle the sum due by way of tax, is it?
Well, on the face of it, that's the C75 declaration. When you go to the rules, the point of the first declaration is to assess the amount. This, as far as it's not entirely clear what the actual purpose of this declaration is over and above that of the first declaration. Although obviously it is confirmatory of the first declaration in relation to the value of the goods being specified and the nature of the goods being specified. My lords, I couldn't find exactly what the purpose of this is. You'll note it may be, my lord, that there are further details, but on the face of it, my lord, it's not entirely clear. But the signatory is Larry Howell. That's, you'll see at the foot of the page, Larry Howell, and my lords, he again is the customs, the Canserve's customs clerk. And my lords, I say that's important because it obviously puts Canserve, again, for the same reasons as in relation to Mr. Nurse, prima facie, at least, they're the ones responsible for this document. My lords, the bill of lading and the worksheet attached to this document are at 345 and 346. Sorry, 344 and 346.
Do we know why Mr. Howells wasn't charged as well as Mr.
No, we don't.
No.
There was no evidence on that. So 344 is the bill of lading, which is attached to the declaration I just showed you. And again, you can see it's to similar effect, Canserve are the consignee, and then you can see the reference to the items in question. and in particular the price, at the foot of the page, total 3,050, which matches the price stated on the C75 declaration, and I think also the C82. And then the other document attached to the C82 declaration is the worksheet at 346. And again, you can see here a breakdown of what the items are and their respective values, and how the duty is assessed. My Lords, these documents, it's not entirely clear on the evidence, but these documents were handed to Mr. Howell, so it looks as if he gives them to the customs, and then he gets them back. They're handed to Mr. Howell for him to go off and pay the relevant duty. And the references to that are page 23, lines 20 to 36, and 25, lines 1 to 22. And then on the 30th of June, Mr. Howell pays the relevant sum by cheque, and you can see that at page 314. I think I'm right in saying. 339. This is the assessment notice. Sorry, this is the receipt. I think I've lost the assessment notice. This is the receipt at 339, and although it's difficult to make out, the total is 31,812.13. Sorry? Oh, thank you, yes. The total here is 31,812.13, which is the combined total of the import duty and the $525. So that's where that figure comes from. And the assessment notice is at page 341, which is issued on the 30th of June, just before Mr. Howell goes off to pay the relevant amount.
Sorry, the last document is page?
341.
Thank you.
And you can see on the assessment notice, it seems to be taking into account the information on the C82 form, which the declarant is said to be Mr. John Williams, but the importer is Canserve. You'll note registration, 24th of June, assessment, 24th of June. So that's why I say the assessment on the face of it was made by, the assessment was made on the 24th of June, but actual payment's not made until the 30th. The goods are then taken for inspection, which takes place on the 10th of July. And my Lords, this is summarised in the Statement of Facts and Issues. If I can just give a very brief summary of what happens. Mr. Nurse is called up on the day before, or Canserve rather, are called up on the day before, saying we want you to come along for an inspection. And Mr. Nurse turns up with Mr. Andrews of Keriri. And Mr. Andrews, according to the Customs Officer's evidence, says that the Canserve had asked him to attend in order to examine gaming machines. Rather gave the game away. We would say.
Comes to mind.
The Customs Officer says to Mr. Nurse and to another attendee from Canserve, well, why are Keriri here if it's just office furniture that's coming in? To which there was no reply. So that's the state of the evidence. And that is at bundle 1, 53, line 39, to 55, line 29.
It's a rather prosaic inquiry, but I mean, why was it necessary to have someone from Korea to inspect the gaming machines?
Well, my Lords, it may, well, we would say, because it was always intended that gaming machines should come along.
But why did they need to be inspected at that stage?
My Lords, it's not clear.
Not clear.
Not clear.
As I say, prosaic and probably entirely irrelevant inquiry.
My Lords, the closing submissions in the defence, when the defence made submissions of no case to answer, they are at bundle 1, page 250, line 34, going over to 251, line 30, and 252, line 4 to 24. It may be possible just to take it from the later passage, 252, line 4 to 24. And you can see what the point being taken was on behalf of both appellants. I should say the same advocate appeared for Canserve and for Mr. Nurse, and indeed for the other accused who was acquitted.
What does this amount to in your submission?
Well, this amounts to an acceptance in the half-time speech that it is the defence that we knew that gaming machines were coming in. And that is, in my submission, a material fact for the magistrate to take into account in deciding whether there's a case to answer.
But not realise that they didn't realise that they were prohibited goods.
Yes, I said that's of no significance at all, because the mere error of law as to the nature of the goods coming in, as to the legality of the goods coming in, doesn't provide a defence. There is a case which supports that proposition, which I can come to briefly.
Where precisely do we see, Mr. Knox, that they knew that they were gaming machines?
Well, it may be, my lords, one has to go back to page 250, line 34. I thought maybe it's not there. 250, line 34 to 251, line 30. Carries on, my lords, over to line 40, I think. And my lord, just to answer your question, page 252, line 15 to 24, my lord, I would submit in context. He's saying they were shipped, he's talking about the gaming machines, at the behest of Canserve. That much is accepted, it's not been denied. In shipping these items, they were shipped in a particular way. And so they were shipped as parts, as pieces, and that can only be talking about gaming machines. And so clients would certainly believe that the nature in which they came, the way they were brought in, they didn't fall within the ambit or scope of the prohibited item. The point appears to be taken, well, look, these are not put all together as gaming machines, therefore they are not gaming machines, and that's what we sort of thought. So it'll be all right. But the trouble is, once the Court of Appeal's finding comes along, saying it doesn't matter if they're put together or not, then that defence completely goes.
They don't immediately fit the description of office furniture, I suppose.
Sorry, my lords, I missed.
They don't immediately fit the description of office furniture.
Unless, of course, you want to...
Unless you want a gaming machine in your office.
No. On the face of it, it's a pretty big discrepancy. My lords, that being the state of the evidence and the issues in the case, what I say as to the correct view of the respective offences is this. Taking section 213, the importation charge first, I say on any footing there's a clear prima facie case against both Mr. Nurse and Canserve of importing prohibited machines. Mr. Nurse was obviously closely involved throughout in the transaction, and on the face of it he was acting on behalf of Canserve, and it was never denied or disputed that he wasn't. The only serious defence which I say could have been run, namely the items weren't put together as working gambling machines, was rejected by the Court of Appeal. My lord, that's at bundle 2, 596, 18 to 20. And ignorance of any prohibition, I submit, is irrelevant. My lord, that point is dealt with briefly in a case called Simmons, which I shall come to later. Essentially because 213, you do not read into 213A the word knowingly. It takes you at least that far. In other words, there's no knowingly. So if you just bring in prohibited items, that's it. It might have been different if the charge had been knowingly bringing in prohibited items. Query. My lords, I therefore say, in law there was a clear case to answer, essentially for the two reasons I've given. First, proof of the actus reus gives rise to a prima facie case to answer, even if guilty knowledge is necessary. My lords, my lady, there are quite a few cases we cite as authority for that, paragraphs 14 and 15 of our case, page E730. But there is a specific authority, which is Barbar, which is at tab 30, page E1311, in the context of a virtually identical provision in Jamaica. And perhaps I should just take you to that. It's 1311, so it's the bundle 5 of the authorities bundles.
Page.
1311. The offence in this case is, in all material respects, identical. I think you can find the offence itself. I thought I saw it a moment ago. Perhaps I can just ask you anyway, just to go to 1311, 362, the top of the page. This is in the judgment of Mr. Justice of Appeal Fox on an importation case, and identical terms. And you'll see the second paragraph, or the first paragraph. I ask you to read the first paragraph, second, and then subparagraph 1 underneath that. On page 362, yes.
Yes.
My Lords, in our case, we refer to a number of other points. For instance, the other sort of best hits, the case of Warner, which was being caught in possession of drugs in 1969, a House of Lords case. And each of their lordships said, once it's shown that you have the drugs under your control or possession, then a prima facie case arises from that alone, and it's up to you, the defendant, then to put something forward to explain how it is these goods, these drugs happen to be on you. I said it's a point of law, but really it's a point of common sense. It's not for the prosecution to disprove what you might call defences like accident, mistake, and duress, and so forth. So I say, first of all, the actus reus was proved, but secondly, I say, on the evidence, the intention to import gambling machines was overwhelming and uncontradicted. Turning to section 212A, my lords, my lady, there was first of all clear evidence of falsity of the C75 declaration. First, because it included the invoice, and that invoice itemised the relevant goods as office furniture.
Go a little slower, Mr. Martin.
Sorry.
Forgive me. So there's evidence of falsity of declaration.
Because it incorporates the invoice and thereby says that there are the goods coming in are office furniture and so forth, when in fact they're not. But also because it says there are no restrictions on the goods, when in fact there are restrictions on the goods. They're unlawful to bring in. So I say, just as I do in relation to section 213, the actus reus has been proved, that is, say, a false declaration, therefore prima facie case arises just like that, in any event.
Section E1 now?
Section 213A, forgive me. This is section 212A.
Yes.
This is the C75 declaration.
Yes, thank you.
The 23rd of June declaration. Incorporates invoice, false, therefore prima facie case just like that, for the same reasons as before. But further, if we had to go further, we say the facts that came out in the prosecution case were sufficient to raise a prima facie case because there was specific evidence of knowledge of falsity. That is to say, the acceptance or the evidence that gaming machines came in, and albeit as shown on the inspection on the 10th of July 2009, whereas the declaration of the 23rd of June said it was going to be desks. And if they knew on the 10th of July that it was gambling machines, one infers they realised that on the 23rd of June too. on the face of it. My Lord, my Lords, my Lady, can I just deal with the vicarious liability point here? Mr. Nurse plainly signs the form on behalf of Canserve. We say the relevant authorities in this context are ready-mixed concrete and Meridian. These are at tab 44 and tab 28 of the bundle. And at tab 44, this is in bundle 5, this was a case, I think, about a cartel. And one of the points the defendant said, oh, well, the defendant's board said, well, our board didn't authorise this cartel. It was done by our naughty employees.
Do you have a page for that?
Yeah, sorry, my Lord. Tab 44, E 1486.
I don't think it is.
So tab 41, tab 41,
yeah.
1476. So the issue being raised by the defendants was, well, how can we be liable for the acts of our employees for entering into this cartel when we gave them absolutely no authority to do so? And indeed, I think they may have added the argument, and we specifically told them not to. That didn't go down too well with Lord Templeman, who basically puts it at 465C to E on 1486. At 1485, he summarises what the Court of Appeal had found in favour of the company being accused, but then he goes on to say at 1486, second paragraph and third paragraph, well, perhaps I can just ask you to look at that in the interest of time. He says what the principle is when you're looking at whether a company is to be fixed with liability in a criminal context. I submit the same principle applies when making declarations. My Lord, the really important point is 465D. An employee who acts for the company within the scope of his employment is the company. Directors may give and so on. So it doesn't matter what level you are. Of course, a lot will turn on the nature of the legislation, but on the face of it, there's no reason why a company should be able to get away with saying, oh, well, that was my naughty employee. But here, on the face of it, Mr. Nurse wasn't just a naughty employee, he was acting with authority. My Lords, the other particularly important point I would just like to go to, tab 28, is the Meridian Finance case. My Lords, is a well-known case, but there's just a passage which, in Lord Hoffman's opinion, near the end of his, sorry, my Lord, it's page 1272 is where it begins. But it does have a particular importance to the facts of this case at 1283. Because Lord Hoffman here is addressing the argument similar to that run by my learned friend, namely that it has to be shown somehow that the directing mind and will of the company authorised the particular act in question, and if you can't show that, then you're not liable. The company's not liable. Pick it up at 1283F. It was therefore not necessary in this case to inquire into whether coup could have been described in some more general sense as the directing mind and will of the company. But their lordships would wish to guard themselves against being understood to mean that whenever a servant of a company has authority to do an act on its behalf, knowledge of that act will for all purposes be attributed to a company. It's a question of construction in each case as to whether the particular rule requires that the knowledge that an act be done, has been done, or the state of mind with which it was done, should be attributed to the company. Sometimes, as in resupply of ready-mixed concrete, and in this case it will be appropriate. Likewise, in a case in which a company was required to make a return for revenue purposes, and the statute made it an offence to make a false return with intent to deceive, the divisional court held that the mens rea of the servant authorised to discharge the duty to make the return should be attributed to the company. And then, on the other hand, the fact that a company's employee is authorised to drive a lorry doesn't lead to the conclusion that if he kills someone by reckless driving, the company will be guilty of manslaughter. My Lords, I would submit we're much closer on the facts of this case to the making of a false return by, on the face of it, a person who's an employee of the company. And my Lords, what Lord Hoffman here is talking about is where on the face of it, the employee does not have authority to make the return. In my submission, if the employee has authority from the company to make the return, and the company intends him to make that return, well, of course the company is liable. The point might only arise when the employee goes off on a frolic of his own or gets something totally wrong. But in the context of these offences, in my submission, whatever the liability, whether it's strict liability or guilty knowledge, whatever the liability, in my submission, the obvious intention of the statute is to impose a liability upon the company for the declarations made by, on the face of it, it's apparently authorised, it's authorised agents. My Lords, I think that deals with section 212, section 212A. I should say, for the reasons I mentioned earlier, even if knowledge is required under section 212A, quite apart from the prima facie case point, there was obviously evidence here from which one could draw the inference of knowledge, guilty knowledge, as a prima facie case. Turning to section 214, as far as Canserve are concerned, can I deal with Canserve and Mr. Nurse separately? As far as Canserve are concerned, it's clear that the actus reus has been proved against Canserve, A, because it was the importer of the goods, which arrived on the 24th of June, that's clear, and secondly, on the evidence, it was its own customs clerk, Mr. Howell, who signed the C-82 declaration on the 29th of June. So that, in my submission, obviously gave rise to a case against Canserve on any footing. As far as Mr. Nurse is concerned, he didn't sign the C-82 form. On the other hand, I say on the face of it, there was a prima facie case that he caused the original importation because of his involvement generally in the importation. And further, the importation was still continuing as at the 29th of June when the declaration was signed because the payment had yet to be made. It's then, and then I also say it's a fair inference that as Mr. Nurse had signed the false C-75 declaration, he knew that a false C-82 declaration would also be signed. And therefore, there was a prima facie case against him personally for importing goods that didn't correspond to the C-82 declaration. And that being the case, there was either a prima facie case against him, either on the principle that he was guilty of the actus reus alone, or because there was positive evidence that he knew that the C-82 form would be signed and would be false. My Lords, that's the first part of my submissions. Can I now go to strict liability? And my Lords, it's a point that's already been made by the board, but it is worth reiterating, and that is the Court of Appeal did not say that the relevant offences are for all purposes and in all circumstances, no matter what the facts, offences of strict liability, and one gets that from page 635 of Bundle 2. Paragraphs 92 to 93. Court of Appeal make it plain, 92, it doesn't, the operation of the strict liability principle does not mean that certain types of defences are not available. And then it quotes from Barber, which I'll come to later, and Hong Kong v. Sea Hung Limited. And that A and B are given as examples where there may be exoneration, essentially the innocent merchant or the innocent labourer. And you can see what they mean by that, by their quotation from Lord Bridges' opinion, I think, in the Sea Hung Lit case, where he, in relation to similar export legislation, he says that you're not liable just because you're the stevedore or the road haulage contractor and so on and so forth, who has no opportunity and no knowledge of inspecting the goods. And so, my lords, that is the limit of what the Court of Appeal has said.
May I ask, in the first sentence of paragraph 92,
Yes.
that's double negative.
Yes.
Is it your submission that the Court of Appeal is saying that there are certain types of defences available, but we're not going to expand upon their limits, or is it saying there may be defences? You say it's the latter.
The latter, yes. My lords, I would submit that that fits in better with the sense of what they're saying. In other words, what the Court of Appeal is saying by the double negative is that there may be defences, other defences, but we don't have to adjudicate on those.
I think for your purposes, the important thing is what the Court of Appeal is not saying. It's certainly not saying that there is strict or absolute liability in all circumstances.
They're leaving that open.
But whatever they may be, none of the circumstances of the present case comes within the possible spectrum of defences.
My lords, that's exactly it.
They are saying some defences exist. We're just not going to describe the boundaries.
Well, may exist, I think.
Well, it does say examples of these defences include the following.
Yes. My lords, I think that might go back to what is meant by the first sentence in paragraph 92, whether they're saying there are other defences or there may be other defences. But we don't have to deal with that. My lords, my lady, the reason I say that in paragraph 93, they seem to be reserving the position generally, especially the last sentence of paragraph 93.
Yes, but the fact that they have taken care to describe the mistaken belief in 92A in narrower terms than in the existing case law suggests that they had actually thought that that was going to be a defence.
Yes, my lady, I, in a sense, one's interpreting what they are saying, whether they're saying, it goes back to my Lord Kitchen's question, how far are they committing themselves? And my lady, it may be difficult to say they're committing themselves clearly to one point of view or another.
It's obiter, undoubtedly,
Yes.
on the way you've presented the case, but even so, they've expressed a view. That
Yes, they've certainly expressed a view that this, at the very least, may be open, and perhaps they've expressed a view that these are defences, as opposed to maybe defences. But my lady, I submit it doesn't really matter for your lordship's purposes on this appeal, whichever explanation it is, because it will be for your lordships, as it were, to express your own view, at least on whether it should be a maybe case or an is case. My lords, I would invite you simply to say maybe. There may be such further defences.
Well, the way it's put against you is that if there are not such defences, then that points against this being a strict liability offence.
Yes. Well, my lord, to what I say to that is that you have my submission. There would be on other types of case. Yes. For instance, the innocent handler.
But you're going further than the Court of Appeal. You say that there are other defences, although we don't have to look at their scope.
I would, my lord, if I was pushed, if I had to, I would say there are other defences. But my primary position is it's not something this board needs to get into. But if one needs to answer the question, the strict question before you, by reference to other questions, then my answer is there are other defences. In particular, what you might call the luckless victim defence, which does appear to be well established in authority. But I'll have to come to that.
It's probably not necessary to examine the exact contours of the defences, but is it not necessary at least to acknowledge that there are defences? Because otherwise we've got to decide what basis on which we're, if we do accede to your argument, on which basis we're acceding to it. Well, either that there is a complete charter which admits of no exception at all, or that there are exceptions, but we don't need to define those.
Well, or indeed define the exact limits of them. But my lords, I certainly would say one exception is what you might call the luckless victim. Let's take, for instance, the person who's walking through the airport and someone plants some drugs on him. I don't think I could possibly. And I don't think anyone has ever tried to argue, in the cases I've read, that you're liable even then. You have no idea it's been planted on you, no opportunity to find out, and you've been taken advantage of yourself. And that might also apply to importation, where you've done absolutely everything you can to check that your supplier is a proper supplier and he's got a proper supply chain as he brings in the goods to you. Because in those circumstances, my lord, it might be said you haven't caused the goods to come in, the wrong goods to come in. What's happened is your supplier, for some reason, has chosen to give you the wrong goods without any fault at all on your part.
Are you going to come back to these?
I will, yes. Oh, yes, certainly, my lord, yes.
But that's the halfway house then, isn't it?
Not quite. It's more I've done everything I could conceivably do. This is slightly different from I reasonably believed. And my submission, there is a difference, and I will come to that, though.
But the Court of Appeal has very properly left itself growing room here.
Yes. Well, that's what I say quite right too, as it were. That's my primary position. But if I need to go further to make good, if I can put it this way, a case which is attractive and not totally inhumane, then I do go that far. But I say I don't have to on the facts of this case. As far as, can I now deal with the points of law individually? First, taking section 212A, this is the C75 form. My lords, just a small point, but it is in my submission important. If you go to the regulations, which I'm afraid didn't get into the electronic bundle, but they are attached as an exhibit at, I think, tab 3 to the respondent's written case, you can see what the purpose of the C75 declaration was. That is to say, the 23rd of June declaration.
Two.
Is it 2? I don't. Mine is tab 3. I have the extracts of customs regulations. Maybe it's in tab 2. I don't know. But it should be headed at the beginning, customs regulations made under 263. And you can see the regulation 3, specimens of the customs forms referred to are contained in Schedule 1, and one of those is C75. The comptroller may, by notification, amend them, and so forth. And then you go to 37. The importer of any goods shall, at the time of making entry, or within such period thereafter as the controller may in special cases allow, produce a declaration in respect of the goods duly completed in such form as the controller may require, and give further particulars, as the controller may think necessary for a proper valuation and account of the goods as the comptroller may direct. And the importer of the goods shall deliver to the proper officer an invoice thereof, and combined certificate of value and declaration of origin in the form prescribed. Now, my lords, my lady, I say this is important because it shows the specific purpose of the C75 form is to enable a valuation to be placed on the goods in turn so that the correct tax can be made. And that's important on what you might call the strict liability question, because it is vital that what the customs get is an accurate form, rather than one which is accurate to the best of the declarant's knowledge and belief. There is, now my lords, I submit, if I can deal with the section 212A point, just quite briefly, quite quickly, and just run through my points. Perhaps with the wording open, which you can see at tab 1, I think, of the exhibits to our case. Section 212. The point's already been made.
I think you've made the points in 53 and following, haven't you?
Yes, in our case, yes. I'll just run through them, but just by reference to the page here, the first point, and an obvious point, is the absence of the word knowingly in section 212A as against its presence in section 212C to D. C to E. I'll come back to the point about what about 212B in a minute. Secondly, I say, looking at the form, there is no room for saying it is talking about the declarant's belief. On the contrary, it's an absolute statement. And you'll recall in Patel, there was a reference to a judgment of Sir Owen Dixon in Sternberg, which we have got. I don't propose to take you to it, but it's at tab 44, E1529 to E1530. Essentially, the point he makes there is customs authorities need an accurate declaration so they can assess the tax. More importantly, can I ask you to look at a case called Chamberlain, a New Zealand authority, which is at tab 20, E1212. This is another of the cases referred to in Patel. It's the fifth bundle of authorities, tab 20, E1212. This is, I think, just a High Court decision of Mr. Justice Cooper. The charge you can see, if you go to page 87, halfway down the second column on the right, about halfway down you'll see under section 243, if any person shall in any matter relating to customs make or subscribe, cause to be made, subscribe to any false declaration, or make or sign any declaration, and so forth, required to be verified by signature, the same being false, in any particular, such person shall be liable to a penalty of £100. So it's not identical wording, but same idea. There doesn't appear to be any mens rea written into the provision. The important point I want to get out of this case is at 1214. After discussing other matters in the case, about halfway down the left column on page 1214, there's a line beginning Ewart, a little bit more, 2/3 of the way down. And then Mr. Justice Cooper continues, now, section 243 was intended to protect the revenue by making a false statement punishable by a penalty. The proper administration of the customs depends very largely upon information supplied by importers or their agents. Inaccurate statements, though made in good faith, if they are in fact untrue, may result in customs duties being assessed at too low an amount, and if not corrected, and they cannot be corrected if undiscovered, result, as well put by Hood, Day and Stevens, in a loss to the revenue and a benefit to the importers. The object of section 243 is to throw upon the person making the direct declaration the obligation of making a declaration which is true in fact, and to penalise the person who makes a declaration which is untrue in fact for the mistake he's made. The only way in which care and accuracy can fairly be assured is to make the declarant responsible for the mistake which by his carelessness he has committed. My lords, I just pause there. Well, in a sense, the point of these strict liability offences is to stop people being careless. Shortly put, essential declarations required under the Customs Act should be true in their particulars if the revenue is to be properly collected. And to ensure this accuracy, untruthful statements, even though made without a guilty mind, are from the mere fact of their falsity a breach of the law. So, my lords, that's one of the cases the Privy Council, as I said, took into account in their decision. And I submit, when you look at the logic behind this, I submit it's overwhelming. One then goes to Patel, which is at tab 9 in bundle 4. Now, it's fair to say, my lords, that this decision could be said to be obiter in the sense that the construction placed on the equivalent provision to section 212A was not decisive because the appellants were allowed off on a different basis. But, my lords, what I do submit is this, and I don't want to run, you've already seen this authority, I just want to make 3 points. First of all, their lordships considered the narrow distinction between false and falsified. They considered what you might call the obvious point that needs to be considered in relation to this section, and they came up with a clear conclusion. Second, they took into account that the minimum penalty was £50, which is more like £1,000 or so nowadays, as a minimum, but they said that's not going to affect the position. And thirdly, they took into account the Shiraz line of cases, which is essentially the Tolson reasonable and honest mistake line of case, and also Lim Chin Aik. And you can see that in particular at, I think, 1017. This was a recent case at that point. 1017 at the foot of the page, F. I can pick it up from E, where they say, first of all, we're conscious of Shiraz and de Rutzen. and then we're conscious too of lim chin aik. So I do respectfully submit, as the board considered everything that has to be considered, and secondly, my lords, this decision has been unchallenged, as far as I'm aware, for 65 years or whatever. I submit it would be quite wrong for this board to depart from it. It may not be a strictly binding decision, because what was said here was obiter, but nonetheless it's of the highest conceivable authority. And I do submit it would give rise to great uncertainty if you were now to reverse it.
But Lord Hodgson allows a bit of greying room, doesn't he, at 363D?
Yes, he allows for the existence of possible defences. But on the facts of that case, my lords, I should have made this point. This was a case where the form apparently falsely recorded the origin of the goods as Morocco when it was Singapore, or the other way around. Now, you can see, again, in that sort of case, you'd say, well, that is a strict liability case. It would be very different if, it could be different if what had happened, the example I gave earlier, supposing what had happened is that someone slips something in to the container just as it's about to arrive, you have absolutely no idea that's going to happen. Nothing to do with you whatsoever. You couldn't conceivably have stopped it. Now, one can see there might, I'm not saying there would be, there might be a different outcome in those circumstances. But, my lord, on the facts of this case, that just doesn't arise. The reason I say that, my lords, my ladies, is because of the what you might call the lim chin aik exception, which does seem to envisage, if you've done absolutely everything you can, then it's not the idea of the law to make you guilty. I'll come to it later, that case, if I may. That's what I say in relation to section 212. As to section 213A and 214, I propose to deal with the proper construction of both of them individually, and then I'll deal with the point about penalties, as I said. As to section 213A, my submission is this. First, this does create an offence of strict liability on the facts of this case. Indeed, it's difficult to see what mistake has got to do with section 213A on the facts of this case. However, in other types of case, a lot will turn on the precise circumstances. In particular, one can imagine cases of, as I've mentioned earlier, the unfortunate victim of the plant, and things like that, where there might be different results. I will briefly deal with those. Thirdly, I say, in relation to 213, the increases in penalty in 1989 and 2007 don't affect the analysis which you should give to the words without reference to the penalty. If I can just deal first with the strict liability point on the facts of this case, it's clear from the authorities, and I don't envisage it's disputed by my learned friend, that there is no need to show an intention to defraud the customs. If one looks at the wording of section 213, one possible argument, which has been knocked out, and I don't think is being pursued, is that you have to show that the importation in section 213A was done with a view to evading import duties, as you see in 213E. And that was the construction placed on a similar provision by the divisional court in Fraley and Charlton. But it was perhaps easier to see how that could have happened in that case, because it wasn't the subsections weren't so easily broken up by A, B, C, D, and E. But in my submission, on the face of it, 213A is absolute, and it's not noticeably, it doesn't have anything to do with knowingly written in, or indeed intent to evade. So that's my first point. Secondly, I say the authorities show clearly that, at least on the facts of this type of case, there is no question of having to read in the word knowingly in section 213A. And the first authority is a Trinidad Court of Appeal authority at tab 40 at E 1474. It's very short.
Sorry, tab.
40, I think. And this was a case where a master of the ship,
Beg your pardon, what's the name of the case?
Ramdois v. Fernandez, 1475, sorry. Begins at 1474 and then 1475. Sorry, 1475 is where it really begins.
I'm sorry, yes, thank you, I've got it. Yeah.
You can see at the top of 1476 what the charge was. Respondents charged that being the master of a ship, the Paladin, imported certain prohibited goods, to wit 25 cartons of whisky and 1 carton of rum. There was in fact no duty payable on these goods as they were coming from in transit from Venezuela. At the close of the case of the prosecution, the magistrate dismissed the charge on the ground that Section 205 required an intent to defraud His Majesty of any dues. In other words, you read A with E. And in the instant case, no duty was payable. And the section is then recited, and the judgment of the Chief Justice, then Chief Justice Furness Smith, is at the foot of the page. My lords, my lady, can I just ask you to read that?
This is an important piece of history, isn't it? That the Privy Council did not go down the Fraley and Charlton route.
Yes. I think later the point is expanded in another a Caribbean case. But essentially they're saying, well, I'm not going to regard myself as bound by effectively equivalent decision of the divisional court. You then have, to similar effect, the case of Barber, which is the Jamaican Court of Appeal case, which is at tab 30, again on virtually identical provisions. It begins at 1292. This was a charge of importing furniture. I think there was a license to import antique furniture, but in fact what had happened was the accused imported non-antique furniture, and so he was charged under the equivalent of Section 213A. And he again took the point that the charge was defective because there was no allegation of an intent to defraud. So the same point as arose in the previous case. And that was then dealt with by the Court of Appeal in some detail in this case, explaining why Fraley and Charlton shouldn't be regarded as binding and why there was no need to show intent to defraud or indeed to write in the word knowingly in Section 213A. The relevant passages are first in the judgment of Justice of Appeal Laku at 1302 D to G. The offences cognizable fall into similar divisions. This is after some discussion of the Fraley and Charlton case at 1298. Well, this is his conclusion. Secondly, the judgment of Mr. Justice of Appeal Fox at 1311 from F going down to 1312B, where again he comes to the same conclusion. You can't read A as subject to the fraud point in E. But noting, you'll note at the top of 1312, the possibility of coming within an exception on the basis that you're not the owner, and so forth.
Right.
It makes the usual point, you can't have importation rules governed by the state of mind of the importer. My Lord, just one point. You'll notice that just above the passage I asked you to read, subparagraph 4, the strict duty will not be required. So what you read, what you've just read, is in the context of, certainly, lim chin aik. And that's, in my submission, the reason for what you might call the Fraley and Charlton exception. The Court of Appeal is saying, well, Fraley and Charlton might be wrongly reasoned, but nonetheless you can get to the same result by the lim chin aik exception. You've done everything you possibly can to avoid the offence, and it's just someone out of your control who's committed it. You'll also note in this case that, perhaps slightly inconsistently, at the top of page 362 or 1311, there are the considerable reliance is placed on Lord Diplock's speech in Sweet and Parsley. In fact, that begins at 1310 E.
So we have on these 2 pages 3 different versions.
Indeed. Indeed, yes. Although disapproving generally of Fraley and Charlton. But the other 2 exceptions appear to be treated as the same, even though perhaps they're not.
Disapproving Fraley and Charlton on the point about intent.
Yes.
But not on the point, I think, about possible defences.
Yes, exactly. The innocent labourer and so forth, no. Just for your note, I don't think I need to go any further, but for your note, Mr. Justice of Appeal Edun deals with the same point at 1315F to 1316D, where he refers back to a decision of the English Court of Appeal and Sir George Jessel, Sir George, I can't remember, Jessel, Master of the Rolls, at page 1315, in a different context, about not imposing the word knowingly before import. My Lords, the next case is Simmons, which is at tab 16 in bundle 4. Which again is on the Jamaican provisions. Sorry, tab 13, not 16, page 1072. And this case essentially upholds the Court of Appeal's decision in Barbar. And I think you can actually get the words themselves of the statute, which I couldn't find in Barbar, at 1074 at the foot of the page. And you can see that in all material respects, it's identical. Now, can I just ask you to note what the Respondents' Counsel, Mr. Dingemans, submitted, perhaps feeling the same sort of pressure as I do not to come up with a case which is perhaps too harsh. But he was saying in relation to this charge of knowingly harbouring that it would be subject, he was saying it's strict liability, but subject to a Sweet and Parsley type defence. And you can pick that up at 1073. I'll explain why I come to this in a moment. You can see 1073G. Court of Appeal correctly stated the mens rea could be divided into 5 groups. If Sweet and Parsley, now the Court of Appeal in Barbar was talking about Lord Diplock's speech, is applicable to groups 1 and 2, a necessary ingredient of those offences is the absence of a belief held honestly and on reasonable grounds in the existence of fact. So that was the case being put on behalf of the Crown to make its case slightly more palatable. You then go to the reasoning, which begins at 1080, I think it begins at 1079 E. And you can see the submission of Mr. Dingemans is repeated, but they say at this point they're not, the point wasn't fully argued, so they don't want to make up their mind about whether the sweet and parsley defence does apply to A and B. Although it might, but it obviously doesn't apply to knowingly harbouring. But what about the other A and B? We don't know. And then you marry that up with what you see at 1080, beginning at line E. As the Court of Appeal's classification in the present case shows, there are 4 groups, but dealing with different stages of the handling of importing goods. Importing, unloading, harbouring or concealing, acquiring possession. And then importantly, on the face of it, these groups are dealt with differently. In the first place, groups 1 and 2, the word knowingly does not appear. And if they're read together, they are offences of strict liability subject to a defence based on sweet and parsley, being available. There doesn't seem any valid reason why knowingly should be read into groups 1 and 2. In groups 3 and 4, the word knowingly does appear, and effect must be given to it. Now, my lords, I wasn't quite sure when I read that whether that was saying a sweet and parsley defence is available or may be available. But anyway, that's the state of play. Barbar appears to say it is available. Their lordships here are saying it might, as I read this judgment, but my lords, they're suggesting it might be available, subject to its availability. So, my lords, what one might say in relation to the importation offences, it's possible, I'll come to this in a minute, it's possible that it's a defence to say that I made an honest and reasonable mistake. My submission will be, in the first instance, that's too soft a test, but I just note that as the alternative position for the time being. Now, can I just deal with the section 213B point, which was raised by my Lord Kitchen, because, of course, 213B doesn't have the word knowingly in. In my submission, the answer to that is, I shall come to the lim chin in a minute, is the lim chin aik exception. If you happen to be the stevedore or the person unloading or loading, and you have no idea and no reason to know, then and no opportunity of knowing, then in my submission you'd be exonerated on that basis. But that's no reason for reading the word knowingly into the statute. It's more that you can show that if you've done everything you can, well, then the liability wouldn't apply. So it's prima facie strict liability subject to you're showing you did everything possible.
That's a good example in the sense that it would be absurd if there weren't some sort of qualification of that.
Well, no one would dare operate as a stevedore or as a road haulier.
Yeah.
I mean,
so there's got to be some qualification.
Exactly. Yeah. So I accept in relation to 212B there has to be some reading in of what you might call the lim chin aik defence. But that would be consistent anyway with what is said in Barbar, which appeared to accept there would be some sort of limitation. My lords, I'm conscious of the time, so I don't want to take too much time on this. There is a third point, and that is what I call the forfeiture point. I deal with this at paragraph 72 of our case onwards. The point is essentially this. The obvious remedy for importing unlawful goods is immediate forfeiture when they're found. That was the position in the 1938 Act in section 205. My lords, can I just briefly, I don't know if you've got a supplemental bundle of authorities, which I'm afraid didn't make its way into the either electronic bundle or the other, or indeed the written bundles. But if I can just ask you to look at, first of all, section 205.
I beg your pardon, which act?
It's tab 1 and section 205 of the original Act, of the ordinance as originally passed. The numbers got changed later.
So what's this bundle called?
It's called supplemental bundle of authorities. It's a fairly thin bundle.
Oh, yes, thank you.
Right. What are you going to tell us about 205?
205 is the equivalent of 213 as originally passed. And you'll see that the final sentence, or rather the final words of the last sentence, and all goods in respect of which any offence shall be committed shall be forfeited. Now, that in my submission, forfeiture, is obviously a strong indication of strict liability, in the sense I'm using it for the purpose of this argument. It would be very odd if you couldn't forfeit until you managed to get some ruling by the court that actually this man came in with a guilty intent.
But it runs together importing and unloading.
Yes, it doesn't have the dividing up into subsections, which we now see in the latest versions.
Does this come straight from the English 1872 Act?
No, I don't think this. I couldn't see this coming. I may have got muddled up. My Lord, maybe it does, but I'm not sure if it's identical. The one, in other words, the provision considered in Fraley and Charlton. But it's very similar in any event. Yes.
Yes, I mean, I remember in a case we've had recently having to look at that Act, this sort of slightly unhappy draft in which bundles everything up together and then says, and forfeiture too, for good luck.
Yes, well, I suspect this is how it was originally passed, and then when the revised editions of the laws, someone helpfully put in the subdivisions. So in other words, it may be the case that the subdivisions were, so to speak, not intended to change the original sense. But in any event, my lords, for present purposes, I submit not much turns on that, but the really important point is there's a provision for forfeiture, as you'd expect. And likewise, when you look at the 1989 Act, which amended this, which is at the next tab along, you'll see on the second page, section 2, the Customs Act is amended. Now, you'll have to go to 2B, by deleting the portion of section 213 beginning with the words shall for each offence and ending with the word forfeited. And then there's a substitution, there's an addition of a subparagraph F. And at the end of that is an outdent, so to speak, and in either case the goods shall be forfeited. So that's the position from 1989 onwards. You then go to the position in the 2007 Act, and it's my submission that it couldn't have been intended to get rid of the power of forfeiture. And you can see what's happened. If you go to the next tab along, this is section 20 of the Finance Act. Page 29 at the top, there's now an alteration in C. There's an alteration in section 213 by deleting paragraph F1 and 2 and substituting the following subparagraph. So it's intended simply to introduce subparagraphs, and it doesn't use the form of words that, which says exactly where you are to stop, with which word you stop. But then you look at what they've substituted. They have missed out the power of forfeiture on the face of it. Now, my submission is that's because it was never intended to knock it out. And you can tell that from looking at D. An alteration is made in section 214 by deleting all the words occurring after the words and substituting. And that would be, if you want to delete everything, you don't just delete a bit. Now, my lords, this is quite an important point as far as the customs are concerned, because if it is said against me that there's no power of forfeiture in relation to unlawful, prohibited goods, well, I submit that's an astonishing proposition and cannot have been intended by these sections. The difficulty is that after the Act is passed, so to speak, in this layout, obviously someone who interprets how the Act should be put into a revised edition of the laws has missed out the power of forfeiture point.
What he hasn't, on your submission, is he simply deletes two particular paragraphs, leaves the tail piece for the subsection.
That's, I submit, the obvious and manifest intention. It is inconceivable that anyone will knock out a power of forfeiture.
You're not asking us to determine that, are you?
Well,
That's an argument against you.
well, my lords, you don't have to determine it, but what I do say is this. The power of forfeiture tells very strongly in favour of this being an offence of strict liability, in the sense which I argue. And we quote in our case an extract from a New Zealand Court of Appeal authority, which in turn is referred to in Barbar, which makes exactly the point that if there's a power of forfeiture, then it makes no sense to require the prosecution to prove full mens rea of guilty knowledge. So, my lords, in answer to your question, I submit, insofar as it is necessary, I do invite you to deal with this point. My lords, the relevant paragraph which you can see this referred to is in Barbar. I won't take you to it. It's at tab 30, at E1309, page 360A, where Mr. Justice of Appeal Fox approves in terms a decision of the Court of Appeal in New Zealand, where Mr. Justice McCarthy had said the power of forfeiture is a very telling factor in favour of strict liability. So, my lords, my lady, that's what I say essentially on section 213A. It is an offence of strict liability. Can I just mention what I say on the other, what you might call difficult areas, very briefly? First, can I deal with the position, what if you are yourself bringing in goods rather than importing them through someone else? What if you are carrying them in as you go through the airport, or so, and so forth? My lords, if you are the victim of an unlucky plant, if you are the luckless victim of a plant, someone just puts whatever it is, the unlawful item in your pocket as you go along, then I submit the view would appear to be that there is no liability at all. My lords, can I just ask you to look at the definition of importing? And that is, if I may go back to the annex to our case at tab 1, it's on the second, I think the third page in of the first annex, the definition. Section 2, in this Act and in any other Act relating to the customs, unless the context otherwise requires, and then drop over a page or two to import. Import means to bring or cause to be brought within Trinidad and Tobago. And then importer, it doesn't strictly rise, but you can see what importer means there. Now, if you are simply bringing, if you're the luckless victim of a plant, I submit that it is likely, although I don't contend particularly, but it is likely you would be regarded not as bringing the drugs in at all. And if I can just give you references to the case of Warner, which was a case about possession, where all their lordships, but the one thing they agreed on was that if you're the luckless victim of a plant, you're not in possession. And if I can give you the references, Lord Reed, it's tab 38.
What case?
Warner. Crown Warner. Apparently it was, I think, referred to in Smith and Hogan, or one of the writers, as the most disastrous case ever in English law, because there are entirely different definitions of possession and so forth, which they came up with. Anyway. But anyway, the relevant passages where...
It's a tab...
Tab 38. This is the one area they all agree
page, please.
Tab 38.
I haven't got tab.
Oh, 1430. Forgive me, my lord. I can give you the references, but the...
Page 1407.
1407.
Volume 5, 1407.
Thank you.
The relevant passages where each of their lordships say there's no question of the luckless victim being liable. First of all, Lord Reed, 1435 A to G.
Sorry, 1435
A to G. Lord Morris, 1438 A to C. Lord Guest, 1450 H to 1451 C. And my lords, he took a very tough line on the case, but he was prepared to allow that exception. Lord Pierce, 1454 D to F. And Lord Wilberforce, 1462 B. There is also the case of I think it's Tau, which is referred to by my learned friend, which is the Australian High Court decision about importation of narcotics, where all the judges say there's no question of your being liable if you are the luckless victim of a plant. And
where do we find that?
That's in volume 4, tab 6. My lords, I don't appear to have all the references with me, but I think you can take
923.
it. Begins at 923. I think 932, I'm just judging from my notes, 932, 974, 978. I'm sorry, my lords, these are rather general references, but I think those are the references where they all say in terms, there's no question of the luckless victim being found guilty. The reason, can I just ask you, while I'm in that case of Hicorte, to go to page 973 to 974, the passage beginning at the foot of 973, importing simpliciter, and so forth. But then he goes over the page, perhaps you can take it from the third line on 974. Therefore, an innocent passenger bringing home his baggage, or an innocent airline or shipping company bringing in consignments of goods, innocent people unloading freight from aircraft or boats, and so forth, would be liable to conviction if narcotic goods have been placed by such others in their baggage, consignments of goods or freight. Such an operation of the provision could not have been intended, as their lordship said in Lim Chin Aik, where it can be shown that the imposition of strict liability would result in the prosecution and conviction of a class of persons whose conduct could not in any way affect the observance of the law. Their lordships consider that, even where the statute is dealing with a grave social evil, strict liability is not intended to be not likely to be intended. And I will in a moment come in a bit more detail to Lim Chin Aik, but I do submit it provides the answer to most of the sort of very tough examples that could be given. My lords, the next question is, what if, and I'll deal with this very briefly, what if you bring in something intentionally, but you don't realise that it's drugs, you think it's tablets or whatever, you think it's something totally different. Now, my submission, but I don't want to go, I'm conscious of time, too far into detail on this, is that you would be entitled to be exonerated if you could show or raise a doubt that there was absolutely nothing you could have done about it. Let's say you didn't have the right to open up the package, things like that. Or it may be you'd be entitled to rely on the defence, or the sweet and parsley defence, as envisaged as a possibility by the Privy Council in the Simmons case, which I took you to earlier, at tab 13, E10A. That might be one way out. There might be another way out, or there might be another defence, namely that you would be guilty unless you had a genuine belief that the items were totally different and you couldn't have inspected them. That would be what you might call the Warner way out. So there are possible ways out if you can show really there was, in essence, nothing you could have done about it, or at least it was a reasonable and honest mistake. But what I do submit is that it is not a defence simply to say, oh, I didn't realise. You have to go further than that. But, my lords, you're not concerned here with bringing in strictly. You're concerned with...
Didn't realise what? Didn't realise that you had something in your possession? Didn't realise it was a prohibited drug?
No, didn't realise it had the qualities which it has. So, for instance, I thought these were Nurofen. Lo and behold, it turned out they were Class A drugs. I had no idea. But there would be possible defences. My lords, my position is you don't have to get too far into that, because you're not dealing here with bringing in person. You're dealing here with importation, which does raise slightly different questions. But I do say, even in relation to this offence, it does require some. You can't just get off it by saying, oh, I didn't know. There is another point, very briefly, if I can make, and that is what you might call the luckless airline passenger. In my submission would be dealt with under Section 63 of the Customs Act, which deals with, this is again in the, I think, as Appendix 1 of our case, which deals with the position of individuals coming in through the airport or through the port. And that's why I say, really, Section 213 it principally governs businesses rather than individuals. It's Section 63 in tab 1 of the respondent's case, Annex 1, going over to Section 65, in particular Section 65. And of course, if you were importing drugs, you would be caught by other laws anyway, quite different laws.
How does this help?
Well, my lords, it shows that the proper, what you might call the individual who comes in, is not likely to be caught by the Section 230, in practice, caught by Section 213A. He'd be prosecuted under different sections, and should be prosecuted under different sections, under different provisions.
Well, maybe you could be prosecuted under either set of provisions.
Well, if you couldn't, then I accept. But one has to come up with a sensible construction for Section 213A, bearing in mind its generality. And I submit the generality is it's not likely to be, on the whole, it's likely to be governing business, importation by businesses and raising taxes. My lords,
This is an offence of strict liability, is it, in 63?
Section 60,
63?
it would appear to be. But it's not such a swinging fine. $500.
Right, well, you've 2 minutes left, Mr. Knox.
Yes, I shall. Two?
Two.
Oh, I see. Right. My lords, can I deal in that case very briefly? As far as importation is concerned, if there is a wrongful act by the supplier who supplies something you simply didn't order and you couldn't do anything about, in my submission, it is questionable whether you would be liable. And that's because of the lim chin aik exception. My lords, for your note, bearing in mind limitations of time, this is at tab 7, E997 to 998. And that emphasises the importance of causation. I also rely on the importance of causation on Hughes, which is at tab 32, E1322 at 1333, paragraphs 25 to 26, and Taylor at tab 37, E1395, para 29.
Sorry, paras?
E1395, para 29.
Para? So,
Para 29.
29, thank you.
Those cases emphasise the importance of causation. And you can't say someone has committed an act, if you can't, a wrongful act, if you can't really say he caused it in the first place. And that would be a possible line of defence for the totally innocent importer. But, my lords, can I make this point? That would only apply in cases where you could show or raise a reasonable doubt that you've done everything. At the other end of the spectrum, if, let's say, you were in some way at fault for choosing a supplier you knew or ought to have realised was a dodgy supplier, then, in my submission, causation is proved and you'd be guilty. And an example of that case is a case called Matudi, which is at tab 8, E1001. And that was an importation offence where the defendant said, well, monkey meat, he imported monkey meat, to which he said, oh, I didn't realise that was coming in. And the prosecution said, well, yeah, but you've already received monkey meat from that supplier before. And so you can see why that defence failed. My lords, there will be the intermediate case where you've seen Glendon-Dale. That was a case, in my submission, which is right. It did impose strict liability, and it did reject the notion that the defendant could escape liability on the basis that he couldn't reasonably have known otherwise, and that's at 908. But, and I submit that's significant, he was running a defence of honest and reasonable mistake. Not enough, says the Court of Appeal in Glendon-Dale. And the reason in my submission, that is correct, because the only way you can get out of it in my submission is if you can show there was nothing you could have done, which is a tougher test. And if he had really been able to say there was nothing he could have done, then the result might have been different. But all he could say is, oh, well, I didn't realise these machines were being packed in a carton of eggs. And maybe it was reasonable for me to think so. That's very different from saying, I did absolutely everything I could to stop this.
Right, well, you've passed your deadline, I'm afraid, Mr. Knox.
My lords, can I just mention one other case? To mention it. What if you import something...
Do no more than mention it.
What if you import something on purpose, not knowing its quality? And there is a bookseller case where a bookseller imports, and it's referred to in our case. But he imports a book called A Cold Wind in August, and a first novel by some New York writer. And it gets picked up on the way in, and he gets acquitted. He's charged with importing indecent material, contrary to the importing. And he is acquitted by the magistrates, who say, well, he had no idea. I mean, why should he? The case goes to the Court of Appeal where they're split. And the president says, well, he had no idea. He's off the hook. But the majority said, no, you're on the hook because you did import that book. And it was your business to know that it was an indecent material or not.
And I'm sure that will shed a lot of light.
Well, I couldn't resist mentioning that case. But
I knew you couldn't.
But it does give
resist going on any further.
But, my lords, it does give an example in my submission of why I say that is correct. If you order something, you're liable if it's of a nature which you could have found out about, but you just didn't.
Right.
My lords,
Thank you very much indeed, Mr. Fox. Now, Mr. Carter.
Section 65, please. Annex 1 to my friend's case. Section 65, which is at page 54, subsection 2b. A person disembarking at a port who carries with him, whether or not contained in his baggage, uncustomed or prohibited goods. The innocent person, my learned friend says, would benefit from the Warner defence. He would not know that he had prohibited goods with him, and therefore Warner would apply, and he would not be prosecuted, and if prosecuted, he would be acquitted, because mens rea is implicit. If it's implicit through Warner into section 65, which carries a fine of $50,000, how come it is not implicit in the similar word provision, which carries a maximum penalty of 20 years imprisonment?
Yes.
Forfeiture. There's a conundrum in my learned friend's submissions about forfeiture. Because if what he says is right, that there is a defence of innocence or innocent knowledge, then the point about forfeiture falls away. Because it would mean that prohibited goods, goods which are absolutely prohibited, including firearms and armoured vehicles, could not be forfeited if a person said, I didn't know they were coming in. It can't realistically be asserted that a person who is responsible for bringing in unwittingly prohibited items can go to the customs warehouse and demand their return to him.
What's the answer?
The answer is that he has no right to them because they're prohibited goods. So the customs seize them and say, so there's no problem. It is not dependent. The powers of the customs are not dependent upon conviction, because if they were, there could not in any circumstances be a defence of innocent lack of knowledge.
I mean, I recall that we had this problem before. There are, as you say, forfeiture doesn't depend on conviction. There are other provisions which allow forfeiture of prohibited goods, I think. But
even if they did...
Anyway, I don't think we are going to get... This case is going to turn on that issue.
I'm sure we can try one way. Can I deal very briefly with some facts and just give you some references rather than reading them out? One of the disputes at the lower court and one of the subjects of cross-appeal in this case is, or rather resistance to the appeal in this case, is the question about a letter which was referred to in evidence by the magistrates. It's referred to in volume 1 of the record at page 250. And in cross-examination, one of the officers was asked about a letter which had been received, referring to a mistake which had been made. Objection was taken by prosecuting counsel to the admissibility of this letter or the contents of this letter from a shipper through the oral evidence of a customs officer who had apparently seen it. and it isn't entirely clear what view the magistrate took about that because she dismissed the case on different grounds. It is equally clear that in this case, at this stage even, the respondents are very keen to object to the admissibility of that letter as a hearsay document. Why? Because it demonstrates mistake or the possibility of mistake. It gives rise to the possibility of mistake. So
Are we referring to the document at 350?
Yes.
That's the removal of containers document.
Oh, sorry, no, not that.
250, I think.
250, thank you.
250. So I better take you to it. It's volume 1, page 250. It's the transcript of the proceedings before the magistrate. Line 42. Then line 43. Mr. Bowler received a letter from the shippers explaining that it was an error, to which he accepted yes. And we went on to ask, is it usual that when you get a letter from a shipper saying that there is error, what happens? And he went on to say, based on the item and based on the value, we then make up our minds whether or not we're going to prosecute it or whether or not we're going to accept it. So that there was in evidence before the magistrate, not a hands up, yes, we're guilty. There was in evidence before the magistrate a proposition, an issue raised that there was a mistake.
But you had brought someone along to look at gaming machines.
We did, and that was, we didn't, the customs did. The person who came along is an agent of the customs.
Hesitate to interrupt. That was not the evidence. And as far as the letter's concerned, the Court of Appeal dealt with that point at 638.
Right.
If he was the agent of the customs, why was the customs officer asking him what he was doing there?
Well, I don't understand that, but he was asked in cross-examination if he had provided reports to the customs, and he said that 2 reports had previously been provided to the customs. So he was an independent agent. Now, whether he was instructed by both customs and Canserve or by Canserve alone, I can't answer that. But the fact was he was there. He was there on the 10th of July, but of course the container had arrived some days earlier. And on the 30th of June, Mr. Nurse had asked for the container to be moved so that it was then subsequently to be examined and unsealed, as it was unsealed by a customs officer. So the suggestion that, as it were, that the defendants have no defence, in fact, is not something that the appellants in this case accept at all.
Well, it will obviously require fairly close examination of the transcript, which is extraordinarily unfortunate, given the background to this case. And surely this is an elementary question. If there is evidence that this was a mistake, I mean, that must have been one of the very first things that you would have pointed to.
What, in the magistrates' court?
No, before, the board.
Well, we took the view that actually what we're dealing with here were issues of law.
Well, they're issues of law, but they're underpinned by factual issues. I mean, now to introduce at this stage that there was a defence in fact available to the appellant seems to me to be quite remarkable. Yes, anyway.
Well, the point I'm making is that the issue was raised as part of the prosecution case.
I mean, this will have to go back anyway. I mean, if you look...
Well, quite. It may well have to go back anyway. So if you find against me, if you find that mens rea isn't required as part of the prosecution case, and some other formula is required, some other state of mind is required, it inevitably will have to go back either to the Court of Appeal or to the Magistrates' Court, where the facts...
Well, whatever it is, it's not for us to decide.
No. And I'm not sure that having a letter would have enabled you to determine the facts of the case or shed any great light on it. Two other matters, my Lord. Again, I'll just give references because of the shortage of time. Tab 6, page 974 of volume 4, please.
Yes.
Can I ask you just to bear in mind, my learned friend read the top of this page, can I ask you to bear in mind the passage starting, if contrary to my opinion, down to the end of that paragraph? If I could simply ask you to mark it.
Could you just tell us what the point is?
Sorry, my lady.
Would you like to just summarise in a sentence what point you want us to take away?
Yes, it relates to the question about the innocent importer and the extent to which the innocent importer can be satisfied that he will be relieved of any prosecution if he can say, it's all right, I didn't know about it.
It's a sort of Wilmington point.
So it is indeed to the Wilmington point, which leads me on to the reference. Yes. Can I then turn to Sweet and Parsley, which is in volume 5 of the bundle at page 1561. And this is where the case of Tolson was considered. And the reference to Tolson starts, I'm not going to read this out, if I can simply give you the references, please. Page 1561, the speech of Lord Diplock, starting at letter C, a more helpful exposition of the nature of mens rea in both common law and statutory offences is found in the judgment of Mr. Justice Stephen in the Queen against Tolson. And referring further down to just below letter F, but only too frequently the actual words used by Parliament to define the prohibited conduct are in themselves descriptive only of a physical act and bear no connotation as to any particular state of mind on the part of the person who does the act. Nevertheless, the mere fact that Parliament has made the conduct a criminal offence gives rise to some implication about the mental element of the conduct prescribed. My submission is that that passage and the following passage, leading down to paragraph D on page 1562, the final paragraph on page 1562, and down to letter G on 1563, which deals with the case of Tolson, effectively identifies what has happened to what was apparently an historic assumption that there was a residual defence of honest belief, which as a result of Tolson and Wilmington, and as a result of Sweet and Parsley and Gammon, has now been transmuted into a presumption that the mental element is incorporated into the elements of the offence, the definition of the offence itself. And therefore, innocent mistake, absence of knowledge, is not a positive defence to be raised. It is a state of mind to be disproved in order to prove, presumptively, the criminal element of the offence.
You're saying that's what Lord Diplock's saying?
Yes. So, giving the historical analysis of how Tolson has fed into Wilmington, and so rather than leaving it to the defence now to raise the issue, if the evidence is there, and of course evidence has to be there, it's not for the prosecution to disprove any fanciful defence that might exist. It is for the issue to be raised by way of evidence, one way or the other. And if it isn't raised in the course of the prosecution case, there is a case to answer. And it is then left for the defence to raise it, if they can, in the course of their own evidence. And if they can't, they will be convicted. And that's the way the criminal justice system works. And that's the way the rule of law works. Those are my submissions.
Thank you very much indeed, Mr. Carter. I'm very grateful to the counsel of both sides, not only those who made oral submissions to us, but also those who no doubt have applied themselves in the preparation of the written submissions. The board will take time to consider their judgment. The court is now adjourned.